Hello.
Hello? Hello?
Hello.
Log off and back in because it says safe driving mode on my phone. So I'll see y'all in a minute.
All right, we'll get started. All right, good afternoon, everyone. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to handle certain matters such as bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. Let's see.
Your Honor, your reset date for your SAP calendar is August the 22nd.
All right, 8/27 is the SAP reset day.
8/22.
Oh, I'm sorry, 8/22.
Yeah, August 22nd.
Gotcha. Thank you. And I want to remind everyone and advise you that this whole entire proceeding is being live streamed as well as recorded, live streamed on YouTube and recorded. So govern yourselves accordingly. I want to remind the defendants on this calendar that you do have a right to representation. You should know who your attorneys are by now. Also, you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of your case can and will be held against you. The state is here and they're listening. So listen to your attorneys. All right, who do we have first, deputies? Courtroom 2.
We have position number 1, Mr. Blancha. There you go.
All right, I'm not going to try that one either. We have 24 CR 005549F. He is charged with 3 counts of simple battery family violence. Pre-trial?
First.
First, okay. State?
Your Honor, that's my case. Good afternoon.
Good afternoon.
This is an incident that occurred, well, actually the report was made on the 7th of August, Your Honor. Police were called to 3715 Milton Park Drive in Alpharetta at about 8:34 in the morning. There they met with this gentleman's wife, Anjana Patel. Her first name is spelled Anjana, last name Patel, Patel. She reported that after arguing with her husband over him not helping getting the kids out of the door for school, he came home and struck her in the back of her head and kicked her in her leg. She reported that they usually have surveillance video in their residence, but because she has to pay for half of it, it hadn't been renewed recently. She did show police video of incidents from July the 13th of 2024, as well as June the 19th of 2024. Police were able to review the surveillance from those incidences, both of which showed the defendant advance on his wife with his sandal that he's taken off and repeatedly strike her. During their investigation and cooperation on the scene with the victim, she reported that she did not have access to the SIM card in her cell phone, that in July on the 13th, her husband had removed that SIM card to prevent her from having access to people and had made it so that she was no longer allowed to use the keys for the vehicle to leave the home. So in front of you today, Mr. Balahadran is charged with 3 different counts, one for June the 19th, one for July the 14th, and one for August the 7th. I don't believe we've been able to be in contact with the victim yet this morning, Your Honor. I understand she was going to obtain a protective order and had been given some instructions about how to do that. If Ms. Cheney, our advocate, wants to jump on and let us know what she has said when we spoke to her or when they spoke to her this morning, that would be helpful when you're ready, and maybe we sound from Ms. Patel. Your Honor, the argument for the state for bond would be $2,000 on each of the 3 counts, no contact with Ms. Patel, stay away from the location, no drugs, alcohol, or weapons while on bond, and that the bond order include a requirement that he make no changes to the utilities or anything related to the rent or property that is the marital home.
All right. Is this your case, PD Kim?
Yes, Your Honor.
Let me sound for the victim first. Ms. Patel. Is anyone on the Zoom by the name of Ms. Patel? And did you say, PD Allen, we were going to ask victim witness if they've spoken to this victim?
We did evidently have contact, Your Honor. She confirmed the events and the warrants and that this has been too many instances of violence for her. She fears for her safety, but she'd not called the police previously because the defendant takes her things away from her, preventing her from calling the police. I believe a TPO was granted this morning, so we will ask that the defendant be served with that while he's in custody. She's asked for a stay away, and he can return one time with law enforcement to get his belongings.
Huh? All right, go ahead, PD Kim.
Yes, Your Honor. My client is 44 years old. He has been out of work about a year, and he does have a master's degree for computer science. He got his degree from New York, and he has been here in Georgia for about 12 years. And he believes well, his wife is also not employed. So both of them are not employed as of now. So he is going through financial challenges. We would like to request for signature on bond through pretrial level 2, even though this is his first arrest, Your Honor. And I do understand that TPO was filed, so we have no objection to stay away and no further contact. We just need one-time law enforcement officer escorted visit and third-party transfer for his twins. They are 4 years old. Thank you.
All right. I'm going to order the $6,000 signature bond through pretrial level 2. That's 2,000 on each count. I'm going to order no further contact with the victim, Ms. Patel. I'm going to also order stay away from the marital residence, 3715 Milton Park Drive. Needs to find somewhere else to live. I'm going to order that he not disconnect or change codes to any of the utilities, the home, cell phone surveillance or videos in the home, so that Ms. Patel can still stay there with the children. And no drugs, no alcohol, no weapons or guns while on bond. And since it's through pretrial, I'm going to order a 1 week of anger management, 1 week anger management course. I'm not going to order anything on visitation. I'll leave that up to Ms. Patel.
Your Honor, I did just receive information that the order for protection includes no contact with the children.
Oh, okay. So I'll add that to mine as well. There's no further contact with the wife or the children, victim or the children. He can have a one-time law enforcement escort back to the property to retrieve any personal items. And it better be by law enforcement. He's not to go back there otherwise, or else he'll be back down here at the jail. And I believe that is all. Did I leave out anything, counsel? Think not. All right, that should do it.
Thank you.
Position number 8, Mr. Pereiro.
Good afternoon, Judge Mary Agramonte. I'm present on his case.
Okay. This is 24 CR 00555 0H. Mr. Piero is charged with 1 count of criminal trespass, 2nd count pointing or aiming a gun or pistol at another. Pre-trial.
It's his 7th arrest. All he has is a bunch of DUIs in his history.
Okay. State.
Your Honor, that's my case as well. This is an incident that was reported on the 4th of August. Police were called to the location, the home of this gentleman and his wife. Her name is Diana Pena. She reported that the defendant, this was a Sunday, had been drinking and was watching TV. She asked him to turn the TV down. Their 7-month-old was asleep in the other room. This angered him. When she retreated to the bedroom where the child was and closed and locked the door, he banged that door open, damaging the interior door, bedroom door. And as she stood with their 7-month-old in her arms, he went and got a firearm out of the closet, loaded it or engaged it, sliding it and pointing the firearm at her and the child that she was holding. She reported being fearful. She called 911 and the defendant fled. Police tried to call the defendant to speak with him, but got no answer. They share an 8-year-old, Your Honor. A warrant was obtained and he was just arrested on the 7th. I do see that there are 4 prior DUI convictions, and this incident on the 4th involved alcohol as well. We would be asking for a $2,000 surety bond on the additional charge. It looks like he's already got a $4,000 surety bond for the initial charge. Our additional charge of the pointing a firearm has been added. We'd request no contact with the victim, stay away from the location, surrender all firearms, and submit to random screens, no drugs, alcohol, or weapons while on bond. Our office has been in touch with Ms. Pena. Given that this has been a week since this incident occurred, she is not willing to say that the defendant or she remembers the defendant pointing a gun at her. She says it was dark and she just doesn't remember. Your Honor, the state's position is that this is a domestic violence situation. These 2 people live in the same home and share a child, and she's just not willing to stand against him on that piece. We'd also suggest that she's not in the best position to make a judgment about safety, given the facts that have just been presented to the court and a significant substance abuse issue. If she is on the Zoom, her name is Ms. Pena, if you wouldn't mind sounding for her.
Right. Ms. Pena? Is it
Yes, I'm
Diane
here.
Pena?
Yes.
Oh, I see. Do you wish to address the court today, yes or no?
Yes.
If you do, you have to turn on your video camera. I have to see you and swear you in first.
Okay. Let me see. How can I do this? Just give me 1 second. Let me check. Oh my God, wait.
Looks
Trying
like
to
it's
turn I'm
on.
trying to turn it around. I'm sorry.
Good. All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I swear.
All right, thank you. Put your hand down. Are you in fear of Mr. Piero?
No.
Do you want to have any further contact with him?
Yes, absolutely.
Okay. And you all share a child together?
Yes, we have a 9-month-old baby boy.
9 months, okay.
Mm-hmm.
All right, I don't have any other questions. Any cross-examination questions?
No, we just want him home.
Hold on. That was not for you. Any
Oh, sorry.
cross-examination questions by the state or by counsel?
No, Your Honor.
I don't have any questions.
All right. Ms. Agamonte?
Yes, thank you, Judge. A little bit about my client. He's 46 years old. He does live in Fulton County with Ms. Pena and their 9-month-old. He is not a flight risk. He surrendered voluntarily last night once I was able to confirm that there was in fact a warrant with Alpharetta PD last night or yesterday afternoon, which when I spoke with Alpharetta, they had only told me about the first warrant, which was the criminal trespass. And so the pointing the pistol was actually something that I had not heard from by either my client, Ms. Pena, or the police. So this is the first time I'm hearing about that allegation. But I will just lay out the Ayala factors. He's gainfully employed. He has no felony history whatsoever, no domestic violence history. He's lived in Georgia for a very long time, 34 years. And the allegation is a broken door frame, which was basically a very minor crack on the inside of the frame. The door itself was not broken. And shortly after this incident, Ms. Pena had actually emailed Alpharetta to say, you know, that door had that crack for a while. It may have gotten a little larger, but the crack was always there. So we're talking very, very minor damage. And I do know Ms. Pena does want him to return home. She speaks very highly of Mr. Piero and his parenting. She says the baby loves him. Baby doesn't go to sleep without Juan. He's the one who usually puts the baby down at night. And so they have a really good thing going. Any concern you have about future incidences, I believe can be alleviated, certainly with a bond condition of no violent contact. So knowing that any, argument or violence will put him back in jail as a result of this case. He'd also be willing to do an anger management course or the Men Stopping Violence class as part of his bond condition. We're just asking for the original bond amount, which was the $4,000 surety bond.
All right. Well, I have to give a bond on the second charge that's been added as well.
I would just ask that it would be broken up, maybe 1,000 on count 1 and 3,000 on count 2.
All right, I'm going to order a $6,000 signature bond through pretrial. That'll be 4,000 on the criminal trespass, 2,000 on the aiming a pistol for a total of 6,000 SOB pretrial. I'm going to order the 1-week anger management course. Don't know if this defendant is in any AA courses or attends AA. Do you know, counsel?
I don't have any information.
With the history of the GUIs, I would order that to at least attend twice a week to AA meetings. I'm going to also order no further violent contact with the victim and child, and no drugs, alcohol, weapons, or guns while on bond.
What's the level?
Level 2.
They might have some classes for him to attend.
They might already have. Okay.
Yeah.
Okay, so I'll say AA or some similar type class through pretrial.
Yeah, like alcohol, substance, or something.
Mm-hmm. Okay. So we'll let him take that class through pretrial, Ms. Agamonte. All right, if nothing else, then that's it for this case.
Right. Thank you, Judge. And may we be
Thank you.
excused?
Yes, you may. Thank you.
All right, next we have position number 7, Mr. Moon.
Good afternoon, Judge. Michael Murphy here for Mr. Javar Moon.
Okay. This is 24 CR 005544A, Javar Moon, charge of 1 count of battery family violence, pretrial.
It's third arrest. 2020 ag assault, given false name. Dead docket. 2018 ag assault battery DV. Simple battery DV not presented to grand jury. That's it.
All right. State.
Yes, Your Honor. Good afternoon.
afternoon.
This incident occurred March 11th, 2024. Officers responded to the Kroger parking lot located at 9000 Marietta Highway in reference to a woman needing to report an assault that occurred earlier that day. They met with the victim, Salathia McDuffie, who stated that her husband of 9 years, the defendant, had punched her in the face. The defendant had asked the victim, Ms. McDuffie, to pick up his medication, and he then became upset because she told him it would take about an hour and a half for his prescription to be filled. When the victim returned home, the defendant confronted her in the doorway of their apartment and then punched her in the face, causing a laceration to the inside of her upper lip. The victim told officers this is not the first time the defendant has been violent, but she continues to drop the charges and called them on that particular day because she wanted to document the assault for their potential divorce. Our office has had an opportunity to speak with the victim, Ms. McDuffie, who stated they lived together at the incident location. The incident location is the Kroger parking lot, but I do have their address, which is 1214 Barrington Oaks Place, Roswell, and that is where they live together. They don't have any children. She confirmed the events in the warrant, but stated that the defendant only pushed her and did not hit her in the face. She did state they have a DV history, 2 previous cases, 18 SC 16-15-48 and 20 SC 17-58-30, which are the 2 instances that pretrial mentioned. She stated the defendant is her best friend and she wants him to return to the residence. They've been living together since this incident in March, and and there hasn't been any violence since, but they are getting kicked out of the apartment that they're currently living in due to this incident. She says she wants to continue contact and wants the defendant to return back to the residence. Given the defendant's history, which is 3 cycles, which only includes violence against the same victim, the state's recommendation is a $4,000 surety bond, no further contact with the victim, stay away from their residence, 1214 Barrington Oaks Place. The state would like to is recommending an FVIP given the defendant's history. If the court is not inclined to grant an FVIP, then at least some anger awareness classes and no drugs, weapons, or alcohol while out on bond. I would like to ask the court to sound for the victim, Salathia McDuffie, if she is on the Zoom today.
Yes, Ms. McDuffie. I don't think she is. All right, go ahead, Mr. Murphy.
Thank you, Judge. My client is 41 years old. He's a veteran of the United States Navy. He is currently a disabled veteran and has a lot of medical conditions that I prefer not to go on open record with public, but just so the court's aware, that require him to seek medical attention from a doctor as well as prescription medication, et cetera. I would tell, and I know pretrial mentioned this, both of those cases that were referenced by them were not convictions. They were dead docketed cases. And I'm learning today that Ms. McDuffie, is further saying that he never struck her. My client maintains his innocence. I have received a copy of the incident report. I mean, it's troubling in that Ms. McDuffie evidently would not allow the police to examine her or take pictures of the alleged cut to her lip. So we look forward for this case to eventually progress through the normal judicial process and move forward. Whatever the court is inclined to do in terms of a bond, financial means are not necessarily there right now, as Mr. Moon has been trying to seek employment, but due to his disability, that is a result of his service in the Navy, it's been difficult. So if the court is inclined to give a surety bond, we'd ask it to be in the amount of $2,000, if not a signature bond. I don't know that family violence intervention at this juncture is appropriate, but if there's an anger management course that makes the court feel more comfortable, then we would ask the court to make that a condition of the bond. Additionally, Ms. McDuffie has reached out to my office. I tried to call her back before this hearing as well as this morning, and been unable to get to her, but it sounds like the state has, and she does want contact with her husband. So we'd ask the court to put a condition of no violent contact while this case is pending. Thank you, Judge.
And the state is vehemently opposed to any no violent contact. This is someone who appears to be in a cycle of violence. Yes, those cases were dead docketed, but as she said, this is her best friend. So of course, she's going to drop the charges. That doesn't mean that she's not in an abusive situation and needs to be protected. So we are definitely going to push for no further contact with this victim.
And Mr. Moon, I'm sorry.
I see that she is on the Zoom call.
Oh, let's see where. Ms. McDuff,
Yes, I'm here.
do you wish to address the court today? Yes or no?
No.
Okay. All right. I was going to ask Mr. Moon, or do you know, in the meantime, this date of the offense is March the 11th, and we're now in August.
And I can address that, Judge. Mr. Moon contacted my office, retained us once he learned that there was an active warrant. He turned in yesterday. So he lives in Fulton County. He's not a flight risk. He's trying to address this issue. He had some medical issues that he had to resolve prior to going into custody, which I think, given the circumstances, was probably good because it would have put him in a great risk to go into a facility like the Fulton County Jail with the medical conditions that he has. So he's took care of his medical conditions, turned himself in, and now we're in a process of getting him out. So, I know this case is accused. It appears it's assigned to Judge Roth. I'm retained to handle the case. So he's going to be coming to court, and I don't see any issues with the bond.
Yes. Has he been residing with the victim since March?
Yes, Your Honor.
I just want to bring to the court's attention, I was just informed, it looks like the victim did seek a TPO as well in 2018. So that is just something else to add to the cycle of violence that she seems to be in.
Again, I mean, I'm looking at the incident report, and Ms. McDuffie indicates that the reason that she was called for So to be documented for a civil divorce. So I'm not we got a long way to go here. I understand the state's position. I understand these arrests, but they're not convictions. And I'd ask the court not to hold that against him. He's not been convicted of any of those charges. They were dead docketed by the DA's office, who is more than capable to determine whether or not there was sufficient evidence to proceed, and they chose not to. So some
He
of those
actually completed pretrial intervention on both of those cases, Your Honor. The victim told police that she had dropped the charges on his prior cases, and to use the fact that the victim wants him home, but also at the same time attack her credibility because she didn't allow police to look inside of her mouth at her injury is very strange. She sought a TPO in 2018. I don't think a lot of what you're saying has a lot of merit when what we're talking about is someone who is obviously in a cycle here. Yes, this will be litigated further, but the issue at this point is that there's a visible injury, there's prior violence, period. It doesn't have to be a conviction. And you've got a victim who is already saying she's mitigated for this gentleman in the past, and she is now already saying maybe it wasn't that big of a deal. So she certainly needs the help, and people in the community need the help.
Judge, I don't have any further response. I'll leave it to discretion of the court. The court's more than capable of making a decision in this case.
Okay. I'm going to order a $2,000 I'm sorry, a $4,000 signature bond through pretrial. And with that 4,000 SOV pretrial, I will have him to report as level 2. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I'm still a little apprehensive about the contact. I guess if she goes to get a TPO after this or reapplies, then maybe she'll get it. I don't know, but I'm going to order no further violent contact between the parties. I'm going to order him to take 2 weeks of anger management courses through pretrial. Not going to order FBIP at this point. That can come later down the road. And I think that's it. Anything else? Did I miss anything, counsel?
Judge, the only thing I would ask, he does have a lot of prescription medication. If he needs to take those to provide those prescriptions of pretrial, I know you said no drugs and alcohol, and we're completely fine with that. But if he has a prescription, I'd ask that be able to take those.
I sometimes forget to say unprescribed drugs. Prescribed drugs are okay, but I say that sometimes and then I forget. So no unprescribed drugs.
Thank you.
All right. I think that'll be it.
Thank you, Judge. That concludes my business of the court. May I be excused.
Yes, you may. Thank you.
Great day.
You too.
Next, we have on the add-on calendar, position number 1, Mr. Joyner.
Ms. Holly, I'm going to let you read that. I did not see the add-on calendar.
Okay, what position on add-on? Did you say 1?
Yes.
Okay, that would be William Schuster Joyner, case number 24 CR 005551Y. Charged with simple battery, family violence, and also simple assault, family violence.
First arrest.
Thank you.
And good afternoon, Your Honor. Attorney Tracy Dorfman here. I'm covering this for Noah Pines, my partner. He's in Athens.
All right.
And I did want to let you know as well that the parties in this case are brother and sister, and their mother, Aline Joyner, is on the Zoom as far as the no contact question.
Okay. Thank you.
That's
All
my
right. Go
case,
ahead,
Your Honor.
State. Okay.
Thank you. This is an incident that occurred on the 6th of August, Your Honor, at 420 Canterbury Lake in Milton. On scene, police spoke with the sister of this young man who is 17. We were unable to speak with her today because she's at school, although we did have contact with her father, who basically said she shouldn't have spoken to his son the way that she did. So a little victim blaming there. The victim reported that during an argument, her brother pushed her down on the ground, grabbed her by her neck. We have not been able to do an assessment on what that specifically looked like, grabbing by the neck, and kicked her in the stomach. She also reported that he raised his arms as if he was going to strike her and threw some property around the house, damaging a window. I sent an NOD order over for criminal trespass just based on our conversation with the father. I'm guessing the property damaged belongs to parents, not the 17-year-old. So obviously we're not going to rely on parents who think that this young woman should have kept her mouth closed to substantiate a charge. I don't know if there were any visible injuries. Again, we've had no contact with the victim, who is a minor. So today we would ask for a $4,000 surety bond, Your Honor, to stay away from the victim. Her name is Vivian Joyner. Stay away from the location and have no drugs, alcohol, or weapons while on bond. We have not had a chance to talk to mom, although she's clearly here and is going to, let you know.
All right, this is which position on the add-on?
1.
His name is William Joyner, Your Honor.
There are 2 additional charges that are not on the calendar, Your Honor.
All right. So there's a simple battery, 2 counts of simple battery, and then
There's a simple assault.
uh-huh,
I'll pull it.
and 1 count of criminal trespass.
No, I got rid of the criminal trespass because I'm guessing
Okay.
the property he destroyed or damaged doesn't belong to the victim in this case.
Okay.
There are 3 counts of simple battery and a count of simple assault for raising his arms at her like he was going to strike her, which causes her to be in fear.
All right. So 3 counts of simple battery, 1 count of simple assault.
Yes, Your Honor.
Okay.
Is that what the warrants are for now?
No, those
Or
are
has it
the
been
accused
accused?
charges.
I'm sorry. Would you
Those
say?
are the charges that were accused by our
Okay.
office.
I'm sorry, could you repeat that? You said 3 counts simple battery
Yes,
and 1
simple
count simple
battery.
assault?
Yes.
Thank you. Your Honor, my client, Mr. Joyner, or Noah's client, Mr. Joyner, is 22 years old. He did graduate from high school. Again, this is his first lifetime arrest. He is working at the Goodwill Donation Center. He loves working there from 9 o'clock in the morning till 6 o'clock at night every day. He definitely regrets what happened in this case. Again, their mother, Aline Joyner, is on the Zoom. She has told me that Vivian, that her daughter, has no problem with him returning to the home. This was
Your Honor, we're going to object to that. Honestly, the daughter, who is actually the victim in this case, has not been spoken with, and she's not here.
Your Honor, Ms. Joyner spoke with, I guess they told the victim witness people, and they said that she could speak because her daughter was a minor. So she could speak on behalf of her.
Possibly, but let me let you finish your
Okay.
presentation, and then I'll decide if I'll let mom speak for daughter.
Okay. So we would be asking, the $4,000 surety is I think is appropriate in this case. But we would be asking for no violent contact. William has absolutely nowhere to go. They have a large home, plenty of space in the home. They would not be on top of each other. Again, this is the first time there's been the police at the home for this, and well, I think Ms. Joyner would answer any questions. And I think as far as the damage, there was a pane of the window that was damaged in this case. However, also, I think the police noted that there was no visible injury, and I think Ms. Joyner can also attest to that.
All right, Ms. Joyner.
Yes, ma'am.
There you are. Okay. Would you raise your right hand for me, please? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right. And your daughter is 17?
Yes.
All right. And she's in high school?
Yes.
And then your son, the defendant, is 22?
Correct.
Does he work or is he?
Yes, he works.
She said the Salvation Army, I believe.
Goodwill,
Or
Yeah,
Goodwill
Goodwill.
donation.
I'm
Yeah.
sorry, Goodwill. Okay.
Yeah, that's
All
a paid position. It's
Okay. So he's not volunteering.
he's not volunteering. Correct. That's his job.
And so were you in the home to witness this incident?
I was in the home. I did not witness the incident.
And you
Right
know-
after the incident.
Can't in after, okay. And then your daughter, she's almost an adult. She's 17, getting ready to be 18. She is a senior in high school.
She turned 17 in June, so she's just 17.
Oh, just turning 17.
Yes. She's actually a senior in high school. She's young for her grade with the summer birthday, yes.
Okay. And do you know if she's in fear of your son?
She is not in fear of him. She understands that he will be returning to the house, to the home.
But I have some concerns about it. Although I know that they're both young and he's young. But I want to make sure there's been the ample cooling down period and that there won't be any additional incidents. Because this happened less than, well, maybe right at 24 hours ago.
Tuesday night. So yeah, going on 48 hours ago. Yeah.
My concern is, does your son have anywhere else to stay, any relatives or anywhere else?
No, ma'am.
Because, you know, in order to make me feel comfortable to put them back in the home together, I would almost need to talk to your daughter. Or she needs to talk to someone in victim witness herself. If she were 5 years old, I'd say, sure, you know, we don't try to put minors through it, but she's adult enough to be able to speak for herself. And the fact that she's not been allowed to, or isn't available to, or can't, bothers me some, to then send her
Well, it's not
brother.
that she hasn't been allowed to. I mean,
They just called while she was in school.
yeah.
So I just want to clarify, Your Honor, no one in our office told their father that we were going to try to talk to mom or try to talk to the child and we needed an adult, or
I didn't say that.
why don't you remind me what you said?
I just said I was under the understanding, and it may have been, and I'm sorry, Miss Allen, it may have been Mr. Pines that told me that the mom was going to be joining because the daughter was in school, but that she was, since she was a minor, he
Right.
understood. It was his understanding that they could hear from her.
Right. So it doesn't go both ways. You can't say mom has to speak for the child because she's a minor and therefore prevent the court and the state from understanding her perspective, whether she was injured. This mom just testified that she was not actually a witness. And we have a statement from dad saying his daughter was the one who called the police and she shouldn't have said what she said. So that raises concerns about safety. We would like to be able to speak to the actual victim in this case. School's over. Is she available now? Have you spoken to her since? Because I don't want to take mom's word as someone who has said she's not a witness.
I am a witness to,
You just
know,
said you were not a witness to the assault. Thank
She
you.
said immediately thereafter, Miss Allen.
I was here. I've been listening. Thank you.
yeah, the rest of my sentence was, I am a witness to, what her body looked like after the alleged incident.
Thank you.
Where's your daughter now?
She is at school,
School lets out at what time?
3:20.
So I'd be open to holding this to the end of the calendar, Your Honor, or we would request no contact until further order of the court. I think it is
Yeah, we do have some concerns, Ms. Joyner.
Can I say that I could assure her safety within the kind of home we have, that she would be safe here?
Well,
We,
that hasn't happened thus far.
I know, I
So,
understand.
you know, the
that. But
court is, we have to protect the victim.
Yeah,
And Big Brother comes back home to taunt her and to tease her. And if you're not keeping her under your arm, which I doubt that you will, you don't know what's going on. And if you have a big home and they can be separate, that's one thing, but that also means they can be together and you not know unless you're getting ready to now keep an eye on your daughter 24/7. And that obviously didn't happen before. So I don't want to have her to be intimidated or in fear going back home. And, you know, her brother, there's some allegations, some serious allegations against her brother. And for her to not think anyone is going to stand up for her. And so 3:15, 3:30 will probably still be here. I'm assuming she has a cell phone like most kids do. So
Yeah.
can you call her or text her to tell her you want her to call you? Is she a car rider, a bus rider, or what?
we pick her up from school.
Okay. So today your husband's picking her up?
Yes, ma'am. I mean, is there like,
I won't be available.
okay, yeah, is there a way that we could do no violent contact? Because like no contact really does present a,
That's what her decision is between. No contact means that he could not return to the home. No violent contact means he would be able to return to the home, but that there cannot be any more arguments or any kind of, fighting of any kind. So that's the judge's decision right now, is between no contact or no violent contact.
and you're saying we can't make that decision without.
She said, yeah, the judge is saying that they don't want to make that decision without hearing from Vivian.
Okay, I understand. Okay. Yes, ma'am, I could get a hold of her, and bring her back on this call. Is that what you're requesting?
If that can be done by 3:30.
I mean,
This is what, the first week of school, so she
Yeah.
may not have practice or anything. She's in any activities.
yeah, I mean, the school is, 15, 20 minutes away is the thing, right?
So it's close by. And
Well,
counsel, did I hear
15
you say,
minutes there, 15 minutes back, so we're right at, 3:20 to get her back here if we.
So, Your Honor, we would request no contact until further order of the court. There's a risk just based on the testimony that you've heard of the IELA factors of intimidation, a risk to reoffend. And you have a family who clearly does not understand that the victim in this case has a voice and needs to be spoken to as it regards to what happened. And she called the police. It would be a real shame if this were all handled before she even got home from school by her parents.
yes, I do
There's a
have
lot I
some,
disagree with what was just said there, but.
Yeah, I'm not sure why you're accusing Miss Joyner of that she loves her daughter. She would certainly be protecting her daughter. and would
Nobody
not
said
be-
any of those words, but it's interesting that this is all being done and you want it to be done before she gets home from school, and we're having a hard time convincing and explaining to you
No,
that
that's
you
not
are not
true.
a victim in this case. Your daughter is, and we have to speak to your daughter.
I hear what you're saying, and I am representing my daughter's best interests. If I thought my
Not in
daughter,
the legal definition as it relates to this criminal matter, and I appreciate your advocacy.
so if she's available, can be available by 3:30, counsel, are you able to get back on at 3:30?
I guess I'll have to. I will. So you want me to log off and log back in at 3:30?
Yeah, that way I don't want to just tie you up sitting here listening to all the other cases unless you.
Miss Joyner, can you have her be actually able to log in at 3:30?
if she can log in with sitting next to me, or yes, I mean, do I use the same Zoom link?
It's the same link.
Okay, then my husband is leaving right now to go get her. And it is, yeah, so 3:30 we'll be back on this Zoom link at 3:30.
Okay,
Is
great.
that what I'm being instructed to do?
Yes,
Yes,
so you
ma'am.
can You can log off now, but just make sure that she's back on at 3:30, and I'll log back in it as well.
Okay.
Okay, thank you. All right, next case.
Good afternoon, Judge. We have position number, it's an add-on, number 3, Smith. And before we do that, I do have a quick announcement for number 4, Goss. They bonded out
That's 4 on the regular calendar.
on the regular count. Yes, that is correct.
Your Honor, were you able to get your add-on calendar?
I have it now.
Okay.
I'm going to, print.
If not, I have it.
All right, you can go ahead and read it now. I'm printing mine now.
Okay, and what position was that again on the add-on?
This is add-on number 3, Ms.
Okay.
Smith.
Okay, thank you.
You're welcome.
Add-on position number 3 is Antoinette Smith. Case number 24 CR 005552J. Charged with simple battery, family violence, battery against a female who is pregnant, battery, family violence, reckless conduct, and also simple assault, family violence.
14 total. She got an open bench warrant for battery DV. 2022 theft by taking. 2017 disorderly conduct no low. And 2012 obstruction no low.
All
Yeah,
right,
that's my case. This is a incident that occurred on June the 13th, so this is a delayed arrest. Pretrial is correct. This defendant is currently in bond forfeiture status based on her failure to appear in 23 CR 004505J, which is a battery family violence against one of the victims in this current case, Rosinia, who is her girlfriend. The order in that case issued last July prevents or prohibits her from having contact with Rosinia or going back to the location where the incident in front of you today occurred.
okay.
This is an incident that happened at 1188 Joseph E. Boone Boulevard Northwest. The incident she's prohibited from being present at. Police were called by the daughter of the girlfriend of this defendant. Her name is Zakara. Her date of birth is a 2003 date of birth, so quite young. She called 911 and reported that she'd heard the defendant and her mother, Rosinia, in a large argument and heard some banging. She went to the kitchen where they were and she observed the defendant throwing a large pot of food at her mother, getting food all over the kitchen. Rosinia reported that the defendant kicked her in the back repeatedly, causing pain. She complained of pain on the scene. The victim, Zakara, who was 9 months pregnant during this incident and was gone to Grady as a result of the assault here. She reported that she ran to her room after she saw the assault on her mother and she started to gather the defendant's things to put them outside. At that point, the defendant poured gasoline all over the belongings in the home and attempted to light household items that she just poured gasoline on fire with her lighter. Fortunately, she was unable to get her lighter to strike. She then started to repeatedly strike Zakara, who was observed by police to have a bloody bottom lip, swelling to her eye, and abrasions on her face under that left eye. When the victim, Zakara, told the defendant she was calling police, the defendant fled on foot. When police arrived at the location, they saw food all over the wall, things thrown all over the kitchen. They smelled gasoline and saw that gasoline had been poured all over belongings in the location. They also observed the injuries to the young woman who was 9 months pregnant and she was transported to Grady. We have attempted to contact Rosinia Castello, the last name of Rosinia, Rozenia, who is the victim of the simple battery for kicking. and her daughter, the pregnant daughter, Zakara, is Z-A-C-A-R-A-H. Last name is Castello, C-A-S-T-E-L-O-W. We've not been able to get in touch with them yet this morning. It might be because daughter called 911 and she is receiving treatment at Grady, but it also might be because they know that they're having this young woman in their home is a violation of her bond, and she already has a warrant based on the failure to appear in that case. We'd be arguing, Your Honor, for a $5,000 cash bond, have absolutely no contact with the victims in this case, Rosenia and Zakara, and to stay away from the location. In addition, have no drugs, alcohol, or weapons. Thank you.
Okay. PD Kim?
Yes, Your Honor. I have not been able to talk to Ms. Caslow. The way my client was understanding was they both want no further violent contact, and yet we understand the situation because of the history. She has no objection to stay away and no further contact to both victims, Your Honor. We would like to request for a signature on bond through pretrial level 4. She is gainfully employed at McDonald's and Wendy. She has 2 jobs to make us survive. And if she loses both of jobs, it will be very, very difficult for her. She has nobody else to pay for the bond. She does not have to go back to the incident location. She moved out. They don't live together anymore. And we have a good phone number and mailing address for my client. And because of FTA, she has an $8,000 good bond already for those. She will not be able to go anywhere, Your Honor. So we would like to request for a signature on bond through pretrial. Thank you.
What's your client's name again?
I'm sorry, Your Honor.
What's the defendant's name again?
Case low. Rosenia case low.
Rosenia and Zakara.
Ah.
Caslow.
And I am totally lost. I hear all the evidence, but what case is it on the calendar? I don't have that last name. That's what I'm asking.
It's number 3 on the add-on calendar, and the victims are Rosenia Caslow and Zakara Caslow.
The defendant's name is Antoinette Smith, Your Honor, and
That's
I'm
what
gonna.
I've been asking, and that's the first time I'm hearing the name. Keep
Oh,
saying
Name is Antoinette Smith, and I will
Antoinette Smith.
forward you the bond order.
all right.
He signed it.
That's where I was lost because I was twixing between 3 and 4, but I didn't think that was it. Antoinette Smith. All right. So we have 1, 2, 3, 4, 5 counts.
That is correct.
And then an open or bond forfeiture for 8,000.
Yes, Your Honor.
The state was requesting 5,000 cash bond because this is a repeat offender.
Yes, and
Correct.
she's currently in violation of the bond that you signed in July of 2023. I just sent it to you. Requires that she have no contact with Rosenia and to stay away from the incident location where this incident occurred.
Yeah. Well, you know what I always say about those who violate my bonds. They're already asking for a cash bond.
It's 3 o'clock.
Hold on a second. Let me look at this. And that was a modified bond too, right? That's
Yes,
not the.
it looks like it was originally a $3,000 bond and you modified it down to $2,000, but both bonds in that case always said no further contact and to stay away.
Mm-hmm. Okay. All right, I'm going to order the 5,000 cash bond, 1,000 on each charge.
Your Honor, there's no way she's going to be able to pay for a $5,000 cash bond. Originally, there was only 3 charges, and now it became 5 charges. Can we do maximum $3,000 cash bond, Your Honor?
Let's see. Well, I can do 4,000 cash and then a signature bond on the reckless.
Thank you, Your Honor.
So 4 cash and then on the reckless, a signature bond for $1, 1,000 on the other 4 charges. So split bond, 4,000 cash, and then the $1 SOB on the reckless. No
Yeah.
drugs, no unprescribed drugs, alcohol, weapons, or guns while on bond. And I'm going to order again, no further contact with the victims. Stay away from the incident location or the homes and jobs and work wherever they may be. Got to be 200 yards away from these victims. We mean it. Else you'll just keep staying in jail. All right. Is there anything else I need to order?
Nothing further from defense, Your Honor.
All right.
Thank you, Judge.
Mhm.
Thank you.
Next we have position number 2, Mr. Brooks.
This is 24 CR 0055488H. Michael Brooks, charged with 1 count of driving, possession of open alcohol container. Pre-trial,
You said Brooks,
2 on the regular calendar.
12th arrest, 2019 FTA, 2017 trespass conviction. I didn't see any previous DUIs or anything.
Okay. Okay.
Yes, Your Honor. The defendant is accused of possessing an open container of vodka while he was the passenger in a vehicle driven by Barnett Russell. When officers removed the 2 individuals from the vehicle, they both showed signs of being under the influence and were struggling to walk and talk. Since the defendant was a passenger in the vehicle, the state's recommendation is a signature bond, no drugs, weapons, or alcohol while out on bond.
All right. PD, who's this, Cook?
Yes, Your Honor, we would have no objection to that. We would like the signature bond to be through the jail.
All right, I will order $2,000 signature bond through the jail. No unprescribed drugs, alcohol, or weapons while on bond. And I guess that's it.
Thank you, Your Honor.
Mm-hmm.
Next we have position number 3, Mr. Gilmore.
All right, 24 CR 005547J. Philip Gilmore, charged with 1 count of SB, sexual battery. I don't know. The
Do you want
facts
to do
very
last
discerning.
or maybe a breakout room?
I don't know what the facts are. Are they discerning that we need to do a breakout, or can we just stop recording? I mean, stop live stream.
Maybe stop. He's accused of touching a victim inappropriately.
Judge, you want to just do them last?
Yeah, we can do. Can we do him last, Deputy?
Yeah, we can do them last.
Thank you.
We'll go with position number 5, Mr. Harris.
Okay. It's 24 CR 005546F, Malik Harris, charged with 1 count of battery family violence. Pre-trial.
Second arrest, 2023 out of Florida. Possession of amphetamine with intent to sell or deliver. Possession of a controlled substance without prescription. That's all. I think it was dismissed too.
Okay.
Sir, this is my son first time ever being arrested.
Excuse me. Ma'am, you don't interrupt my court that way, and you just don't start talking without permission. Okay, so stay muted. And I see that you're on there. You've put a message in the chat, and I will get to you when it's appropriate. But unless you were a witness and you're just the mom, I'm probably not going to allow you to talk. But please do not interrupt me or my court. Thank you. All right, go ahead, State.
Thank you, Your Honor. Officers arrived at the incident location and spoke with the victim, Sakira Shelby, who advised that she called 911 because she had a physical dispute with the father of her child, the defendant. She went to the incident location to pick up her clothing from the defendant's home, but he refused to let her inside. The parties started arguing and the defendant punched her in the face, which led to them fighting. At some point, the victim fell to the ground and injured her wrist. Officers did observe a scratch on the victim's wrist. The defendant admitted to officers that he did hit the victim. The victim in this case is 15 years old and the parties share a 5-month-old son. Our office has spoken with the victim, who stated that the defendant also broke her phone. So she's currently using her friend's phone, and that is how we contacted her. She stated they were in a relationship and they did live together, but they're not living together anymore. The incident location is the defendant's mother's residence. She confirmed the events in the warrant and stated this is not the first time the defendant has been violent towards her. She stated the defendant had been violent towards her at least 6 or 7 times in the past, but she didn't call the police because the defendant told her calling the police would be pointless and they weren't going to do anything. Some of those past incidents of violence did occur in front of the party's child. She stated that she's now staying with a friend and she wants contact for the sake of their child. The state's recommendation is a $3,000 surety bond. Given our conversation with the victim, our recommendation is no further contact. I do not believe the child is legitimated, but at the victim's discretion, if she wants the defendant to have contact with the child, that can be done through a third party. We are also requesting some anger awareness, no drugs, weapons, or alcohol while out on bond. Our victim advocate indicated that Ms. Shelby would be on the Zoom, so I would ask the court to sound for Ms. Sakira Shelby.
She's how old?
She's 15, but we did think, given the circumstances, it might be appropriate for her to speak.
I hear some bigger. And how old is the defendant?
The defendant is currently 18.
Somebody better be careful. All right, is Miss Shelby on the line?
Jill, I got a question.
Yes.
That's the state. Do you got first arrest? I was just trying to get the history straight since the mama keep typing in the chat.
I had first arrest, but let me recheck that.
Okay. Just making sure. Okay.
So is this not him, or is this a Florida? She's talking about a first arrest in Georgia, or
yes, first arrest in Georgia is what I have seen.
But this Florida arrest is not him?
I'll look further into it while they talk.
Okay. And Miss Shelby, do you have an adult with you?
I don't currently have an adult with me. It's just me and my baby and my friend.
And you're 15 years old?
Yes, ma'am.
Have you spoken to the state's victim witness advocate?
No, ma'am.
Okay, I know they've been trying to reach you.
I've
I don't talk to people that I cannot see, but I do have some concerns that you're 15.
I did speak with Miss Shelby earlier this morning, and I spoke with her mom, and she gave us permission to speak with her.
Oh, you spoke to her mom. Who's speaking?
Iman Cheney, victim advocate.
You need to turn on your camera, Miss Shelby.
Yes, ma'am. My camera's on.
I normally don't allow people to come onto my camera with bags on their heads or scarves or things like that.
I'm sorry, I didn't know that. I wish I would have been told that beforehand.
Well,
never
you're
knew that.
coming to court. Would you walk into the courthouse with a bonnet on?
No, but
And
I
this
was
is-
also told I didn't have to turn my camera on.
Well, I don't know who could have told you that.
The prosecutor I was on the phone with, she told me I didn't have to speak or turn my camera on.
You don't have to
Okay,
speak.
well, you know what?
But
You
if
don't
you
have
want
to
to
talk.
speak,
Nobody told
yeah.
you that.
Yeah.
Please move your camera so we can see your face and let the court ask you some questions since you're here.
Okay. Do you want me to remove my bonnet?
Yes, please.
Okay, ma'am. Okay. I'm here now.
All right,
Can you
thank
hear me,
you.
ma'am?
I can see you and I can hear you. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Nothing but the truth.
Okay, thank you. You can put your hand down. And your mother, is she there in the room with you?
No, ma'am.
Okay. I heard some talking in the background and I didn't know if that was you or someone in the room with you.
Oh,
But
my baby and my friend are currently in the room with me. She's with my baby as I speak to you right now.
Oh, so she's babysitting the baby for you. Okay. All right. And the baby's how old?
He's 5 months.
Okay. Do you go to school?
As this school year started, not yet, but I start next week.
Great. I want you to get back in school. All right. Are you in fear of Mr. Harris?
Excuse me?
Are you in fear of Mr. Malik Harris?
I'm not in fear of him, but I know if an argument or anything comes up, that's what will happen again.
Right. Do you want to still have contact with him?
I mean, when it comes to my child, yes, but like, you know, if the same thing keeps happening over and over again, it might not work. So,
All right. So you don't want to be the victim of any more cases with Mr. Harris. Is that correct?
yes, ma'am.
Okay. All right. I don't have any other questions. State, do you all have any questions?
Nothing from us, Your Honor.
And who's representing Mr. Harris?
Keith Cook, Your Honor.
Okay. You have any questions, Mr. Cook?
None of the witness, Your Honor.
Okay. Thank you, Ms. Shelby, for your time. You can hang on and mute yourself. Those are all the questions I have for you at this point. Okay.
Excuse me?
Did you hear what I just said?
I'm sorry. The baby just tried to come in the room. So, he started screaming. Excuse me, what did you say?
I said you can mute yourself now. Those are
Okay.
all the questions I have, and you can continue to listen to the hearing if you'd like. Okay?
Yes, ma'am.
All right. And Mom, I'm not going to, were you a witness to this incident? Yes or no?
No, ma'am.
Okay. So I'm not going to be hearing from you since you're not a witness. This is a bond hearing. This is not his trial. And you're stating in the chat he's never been to Florida. I think they're looking into that to see if that was not his history. And this is his first arrest and not second arrest.
I went back
Pre-trial?
into the
Yes.
I let pre-trial confirm, but I went back into the GCIC and I do see an arrest from Florida. Is his date of birth January 2005?
No, ma'am.
Oh, it says on the booking sheet, January 2006. I don't know. What is his birth date, Mom?
January 3rd, 2006.
2006. Okay.
Yes, it's 3rd though.
So look, the Florida charge was dismissed. I don't know if it's him or not. It's
No, it's
close,
dismissed.
but just say if this is his first arrest, so we could just go off of that based on
Okay.
this stuff.
All right. Go ahead, PD Cook.
Yes, Your Honor. My client is 18 years old. He's not currently working. So he has little income for a bond. Let me see. They do share a child together. They are not currently living together. This is his mother's address. And I think the alleged victim stated that she was no longer there. It's my understanding that she no longer is there. I don't think she ever lived there on a consistent basis. I believe she was in and out. We have no objection to no further contact. Certainly we would like him to go back to the Middleton Road address. That's where he lives. We would be asking for a signature bond at whatever level the court deems appropriate. Nothing further.
Is he a high school graduate or still in senior year or what?
He was in the 12th grade. I do not believe he has finished high school.
I do have some concerns. I have huge concerns for the victim's safety, and the victim obviously wants to be safe and not be the subject of any violence. And we certainly don't want it to escalate. And I'm glad and hope that they're not living together. And it sounds like that this young lady needs some supervision. She's only 15. I'm going to, and I do believe this testimony or the information from the state via the victim was this is not the first incident. And there's been other incidents, and that alarms me.
Yes, Your Honor. The victim stated that's happened at least 6 or 7 times in the past, and the defendant told her you can call the police, but they're not going to do anything.
Right.
Your Honor, since I'm sorry, excuse me. Since they would be living in 2 different places, I mean, he'll go back to Middleton Road. She does not live there on any consistent basis, and so I don't know if that could be considered her residence. We have no objection to no further contact. We just don't want to stay away from him, from his home. As far as the child is concerned, I guess there could be a third transfer. I don't know if you would want that, but I'd leave that up to you. That those 2 awfully young folks were 5-month-old babies. So.
And we didn't ask for a stay away, so.
Okay.
All right, Miss Shelby, you have an address where you live separately?
Yes, ma'am.
Okay, have you provided that to the victim witness advocate with the solicitor's office?
I haven't anybody haven't called me. I don't have a phone, so I haven't spoken to anybody about anything.
Can you borrow a phone and call in to the solicitor's office to speak to the advocate?
Your Honor, we've spoken
Yes,
with her this
ma'am.
morning.
Oh, you did? Oh, she
Yes.
doesn't remember. Oh, okay. They obviously have a way to contact you, I guess.
Yes, I believe through my mother.
Through your mother? Okay. And so is that where you're going to be staying, somewhere like that?
Yes, ma'am, until I start school.
Okay. We're trying to make sure that you're going to be safe and that you don't have to endure any more incidences with Mr. Harris. You all are connected because you have a child. But this is not a good look for this child. This child doesn't deserve to be in a violent relationship or situation with parents or anybody else for that matter. I'm going to order a $4,000 signature bond through pretrial. With that $4,000 signature bond through pretrial, I guess I'll put him at a level 1. I'm gonna order him to take a 2-week anger management course. Gonna order him to have no further contact right now with Miss Shelby. And I mean it, no contact. Stay 200 yards or 2 football fields away from her. If you see her coming, run the other way. And if she allows visitation, it's got to be handled by a third party. She probably shouldn't. But you don't need to talk to her for anything.
Your Honor, our
Right now.
understanding is that she's not living with her mother. She's 15 years old and she's got an infant. So I'm not sure that there would be an identifiable third party that could be responsible for the transfer of a child between these two individuals. And
Well,
the
if there's,
child is
if there's not
legitimate.
one, if there's not one, then there will be no exchange. And mom wants to be that person, his mother.
I don't know if that would be appropriate.
I was getting ready to say, I don't know if I'm comfortable with that right now until this situation blows over or there's been some completion of the anger management courses so he can learn to deal with his anger. I think everybody needs to stay away and stay apart right now till this cools down. And make sure that everybody understands the importance of positive relationships and positive role models for this baby. So, Mom, I don't want you to be that third person right now. They can apply later for a bond modification if that needs to be the case.
He need a cosigner, Judge.
Mom, are you willing to co-sign on his bond?
Yes.
Okay. And
What
tell
do I
us,
have to do?
yeah, give us your full name.
Michelle Harris.
Michelle Harris.
Yes.
Okay, it's 2 L's. I see it on the screen. Okay.
Do I go to pretrial?
Down at the jail, yes.
Okay.
They have a trailer down there. Is that correct, pretrial? They'll direct her where to go.
I think they do it. I think they do it. Well, so the rumor is they do it largely through a link now, so that she might not even have to, come down to cosign, but I guess somebody would have to pick him up. So one way or the other, I believe he has to do it. She'll
Is
have to
that
come.
not true pretrial, or was that with probation?
PD should have the link.
Oh, okay, there's a link. Okay.
Okay.
So he'll get that link to you, Ms. Harris. They have your phone number, correct?
No, ma'am. Don't. He doesn't even have my number. I had just changed my number. Is there any way I could put it in the chat box and y'all give it to him?
Yes. Can you direct chat it to Mr. Cook and not to everybody in the chat?
Yes, ma'am. I will. Thank you.
Okay. Mm-hmm.
And Your Honor, it seems like the victim is indicating in the chat that her stuff is there and she had went to the house to get her stuff. So if we could just confirm with her if her stuff is there, maybe she could get like a one-time police escort to just make sure everything that she has is out of that residence.
Right. I usually order that. I'm going to put in this order that the defendant and his mother will allow the victim to come with a law enforcement escort to get her items. I'm not liking what I'm seeing in the chat. It sounds like there's going to be some room here for more drama and it needs to stop.
I ain't on no drama. That's them making charges. All I said, she can't hear it. I don't understand how after she stayed out or stay gone, did she come here and get my son?
Well, we're gonna order him to stay away from her, which means she's got to stay away from
She
there.
came to our location where we stayed. That's what I'm saying.
Right, and she needs to stay away from that location because she can't be around your son right now. They're gonna take a break. And Miss Shelby, are you listening to me? Miss Shelby.
Excuse me. Yes, I'm listening. And like I said, I was not in the house or any sort. So
Hold on. I'm not getting into the facts. I'm just gonna tell you what's gonna happen going forward. This is not the trial. I'm not getting into that. You're not to go over there. He's not to come where you are. He has to be 2 football fields away from you. You understand that?
Yes, ma'am.
And because of that, you can arrange and if you need the victim witness advocates to help you with that, if you can arrange to have or you must arrange to have a police escort to go back to that location to get your items, do not go back there alone. Because I don't know.
Yes, ma'am, but I have packages and stuff coming in the mail over there because I was told I can get my stuff shipped over there by Malik Harris. So
I
what do I do about
understand.
that?
Then listen to me. And I want you to calm down a little bit. The way you're speaking to me is a little too aggressive for the judge, okay?
I know, I'm very sorry. It's just folks are telling stories and yeah.
Okay, but I want
I'm
you
so
to calm
sorry.
down. I want you to be calmer. So when your packages come, we have an adult there, which is Miss Harris, and she's going to act like an adult. And she's going to hold those packages that you already had to come there. And then she's going to, I guess you'll have to make a call to you or who would she let know about these packages so that you can go back all at once with a police escort to pick up the packages?
I'm not sure if she has my mom's number, but she can call my mom.
She can call your mother. She had Miss Harris, you have her mother's number? You do, Miss Harris?
Yes, ma'am.
Okay. Can you all be adults here and help these young people out and call her mother and say, hey, there's some packages here. I would like to get them to you, and you and her mother meet up to exchange the packages. Would you do that for me?
Yes, ma'am.
Okay, we need to calm this down, and we need to try to teach or show these kids how to act, okay?
Yes, ma'am.
As much as you may not want to, but you have to. You know, the facts are the facts, and they're here. Because I don't want anybody else to end up down here in jail. I'm gonna put on your son's bond condition that he needs to, you yourself, Miss Shelby, that he needs to go back to school or apply and get his GED. Because he has a baby to take care of.
Yeah, he was gonna finish. He got a couple more credits to get this year. He's gonna do that this year and then attend the army.
Oh, so he's on track to graduate?
Yes, ma'am.
Okay, so either one, put that in the order that he should either go to school and finish to graduate or get his GED. So he's got to stay away. He should not be posting on social media, talking about Miss Shelby to anyone. He should not be calling her. He should not be talking about her to third parties or having anybody else to reach her on his behalf. He is to have no contact right now. No further contact. And if she allows visitation with the child, she's got to find a friend or a relative or somebody other than you, Miss Harris, to exchange that child. If it can't happen, it just won't happen. He'll miss seeing his child for a few months until we get back into court and modify the bond order. All right. And no unprescribed drugs, alcohol, weapons, or guns while on bond. And I believe that should be it. And I did say 2-week anger management. Yes. He's got to take that to pretrial and he has to report in at a level 1.
Ms.
And I
Harris,
think
if you could, I'm sorry, you're right. Ms. Harris, if you could get that to me in the link before the session ends, that would be your phone number.
Going forward, no probation matter is deferred by the police officer. No escape about it.
I don't know how to just share it to you, sir.
You see a pull down in that blue box, it should be a pull down and you can select Keith Cook. If you click on the blue box,
Okay, I
you
see.
scroll down, you see it now? You have the number, Mr. Cook? It's Keith.Cook is what it says.
What's that?
I've got it. I've got it. Yes.
All right, thank you. All right, that'll conclude this case. Who's that with Motorola that keeps unmuting? That I haven't given permission to speak? All right. Moving along, that's the end of this case. Good luck to you all.
Can we go back to add-on number 1, Joyner?
Add-on number 1.
Yeah.
All right, this is the Joyner matter.
Yes, Your Honor. Vivian has returned from school and I saw her log in. Vivian, are you there? She may be waiting for the case to be pulled up. Vivian?
Yeah.
Okay. They need to see your face.
Okay.
Okay, there she is.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Mm-hmm.
You need to
Excuse
say
me?
yes or no.
Yes.
All right, and you put your hand down and state your name for the record, please.
Vivian Marie Joyner.
And how old are you?
17.
All right. And you reside with your mother, brother, and father?
Mm-hmm. Yes.
Okay, and your brother's William Joyner?
Yes.
All right, are you in fear of Mr. Joyner?
No.
Did you have an altercation with Mr. Joyner?
Yes.
And do you want to have any further contact with Mr. Joyner?
Yes.
And so you all have made up and everything's wonderful now?
Yes.
That was pretty quickly.
Yes.
Have you had arguments like this before?
No.
This was the first time?
Well, I don't, that's a vague question. What does arguments like this mean? Arguments or
Arguments similar to the one you just had that he was arrested for. Have you had similar arguments with your brother
in the past?
Yes.
Rarely.
Yes or no?
Yes.
Okay. All right, but they didn't result in you calling the police, right?
No.
Okay, but you did call the police this time, correct?
Yes.
Okay. Were you in fear at the time you called the police this time?
Yes.
Okay. And so you think that fear has subsided and you don't have that fear anymore?
Yes.
Okay. All right. Do you think you can stay in the house now without the fear and not have any more incidents going forward?
Yes.
You and your brother talked
Have we? What does that mean?
since this incident?
No. He's
Are
in
you
jail.
going to? Okay. All right. Any other questions, state or PD?
Briefly, Your Honor. Your dad picked you up from school today, Vivian?
Yep.
And did you guys talk
Yes.
about this case?
No, he just said it was a family emergency and I needed to get on the phone for a court hearing, and he said he wasn't allowed to say anything.
That's great. We're so glad. Has your brother ever hit you before?
Before this, no.
Okay. And so when you called the police, the judge asked you, you were fearful, right?
No, what, the judge just now?
She asked you about whether you were fearful,
At
and
this
that's why
point
you
in
called the
time,
police?
yes.
Yeah. Did you have any marks on your body as a result of this
No.
incident? You told the police that your brother kicked you in the stomach?
What does that mean?
Well, it's really not hard, and you can drop the attitude. Please take a moment, okay? Nobody's here trying to hurt you. We're asking you about what you told the police, so I'll say it again. Do you remember telling the police that your brother kicked you in the stomach?
Sure, yeah.
We say yes or no.
Yes.
Use some respectful language and tone, please.
Okay.
Do you remember telling the police that your brother grabbed you by your neck?
For a very brief moment, yes.
So you remember telling the police
Yes,
that?
I remember telling them that he grabbed me by the neck for a very brief matter of 2 seconds.
Okay. I don't have any information about what that looked like, and that's why I'm asking you this question now. Okay? You understand that this is a criminal matter?
I do.
So you should take this seriously and have some
I'm taking it
respect.
very seriously.
Okay, please don't cut the state off. Your attitude is coming through at 100 to me as well. And I'm sorry that we're having to bother you with this, but this is serious. And some people don't live through it. Okay, and sometimes it escalates and it gets worse and worse. And I see the same people back down here. And sometimes you don't make it. So we're just trying to make sure that there's no violence that you in your 15 years of life have to endure, whether it's by your brother, sister, father, mother, or friend.
Thank you.
And we're trying to protect you to make sure you're going to be all right and that you will live to turn 16 and 17 and 18.
She's 17.
17, I'm sorry, not 15. That's my other case. I apologize. 17. And that your brother understands it and you understand it, that it's got to stop. And there's going to be better ways to deal with whatever you're dealing with rather than laying hands on each other.
I understand that.
Okay. And we're making sure that he understands that he doesn't have a right to do it. And you don't have to be subjected to it just because he's your brother or from any other man for that matter, or woman. Okay. So that is the court's duty here today, is to protect you and make sure that you're safe. and that we don't ever see you or your brother down here again. Okay?
Okay.
All right. Anything else?
Our
No.
office will be in touch with you. We would request that you answer your phone so that we can connect with you. You're the listed victim in this case. And that means we can't talk to your mom and dad about what your experience was. Your mother wasn't a witness to this incident, and so we're going to be talking to you, okay?
So we've just asked that you cooperate with them as we go through the process, okay?
Okay.
All right. You can mute yourself. Attorney Dorfman, do you have anything else to add?
I don't think so, Your Honor. Again, I will remind the court, the hearing that was right before this one, there was 3 prior domestic violence arrests, and you granted no violent contact. This one, there's never been any. This is his only arrest in his lifetime. I don't foresee any issues. Of course, none of us know this family for sure, but I don't foresee any issues whatsoever. And I believe that Vivian seems like she would speak her mind one way or the other. So, so I feel confident that we are okay with the no violent contact in this case, Your Honor.
I'm going to order the $4,000 signature bond through pretrial.
Could we just have that be a surety bond instead of pretrial?
I think he needs some classes and counseling and some accountability for a minute. Because he's working, but he's not in school or anything. So I will put him at a level 1. He has to call in. Is it once a week or once a month?
Once a month.
I don't know.
Once a month. Level 1 is once a month.
Okay.
And the reason why I'm doing it through pretrial is so that he can take the 1 week of anger management. So he can make sure that he can deal with his anger
awareness.
issues, anger awareness, I'm sorry. If it comes up again with his sister or anybody else for that matter.
Okay. That sounds good.
No unprescribed drugs, alcohol, weapons, or guns while on bond. And I'm going to order no further violent contact with his sister, Vivian Joyner. And I mean no further violent contact.
So, Mr. Joyner, that means no arguments either. No verbal arguments, nothing. All right.
And I hope the family heals and gets through it. That's all I'll order for now.
What's
Judge,
that bond
is that
again?
$1,000 on each count?
Oh, I forgot there was 2 counts.
I think
No,
they've
it's
got
4
4 counts now in the accusation, correct?
Right. So 1,000 on
correct.
each. Yes,
Thank you.
1,000 on each.
Thank you.
What's the other 2 counts? The same as these? Just double?
It's 3 simple batteries
Okay.
and 1 simple assault, correct?
Correct.
That is correct.
Okay.
Mr. Joyner, you'll be meeting with pretrial before you are eligible to be released from the jail. All right.
Okay. Thank you so much,
Thank
Ms.
you, Your
Dorfman.
Honor. Thank
All
you,
right,
Ms.
thank you.
Allen, for your patience.
Thank you.
All right.
See how time flies. We're still here.
Oh yeah.
Sometimes we hope we're not, but we try to get it right if we can. So thank
All
you.
right. Well, no, I
All right.
appreciate it. I understand
right.
your position.
Right. Thank you.
Thank you.
All right. Who do we have next, deputies?
We have position number 6, Mr. McKeithen.
Huh?
Yeah.
My case, Your Honor. Thank you.
Oh, Mr. McLean. This is 24 CR 005543J. And that is D'Angelo McKeithen, charged with 1 count of interference with custody.
Oh, 7 total. You got an open cruelty in the second. It's 24 PI 003412. 2017 disorderly conduct conviction. That's it.
Okay.
Yes, Your Honor. The parties in this case share a child together. The mother of that child is Brianna Kemp. So the parties had arranged for the defendant to pick up the child on August 2nd and drop the child back off at Ms. Kemp's father's house on August 5th. The defendant failed to drop the child off and said he would do it the following day on August 6th. When the defendant again did not follow through, Ms. Kemp called him and he stated that he was going to keep the child, and then he stopped responding to Ms. Kemp's calls and text messages. The child in this case has not yet been legitimated. Our office has had an opportunity to speak with Ms. Kemp, who stated that her and the defendant are not in a relationship. They do not live together, but they do, of course, share that one child. She confirmed the events in the warrant, stated that this happened a few weeks ago, where the defendant kept the child for about 2 weeks. And when she retrieved the child, they had an altercation which caused the child to be injured. That is where that cruelty to children charge came from. Both of the parties were charged with cruelty to children. The defendant's case number is 24 PI 003412. In that case, the parties were having an argument that led to an accident where the child was not secure in the car seat. The child fell out of the mother's lap. The victim, the vehicle that the parties were in was not in park, and the child was almost run over. The conditions of that bond were that he have no further violent contact with the mother, Brianna Kemp, and that he have no unsupervised visits with the child. Ms. Kemp has stated that she wants no contact with the defendant. I believe, he was with the child for several days, and I'm just going to assume that it was unsupervised, so he is in violation of that bond from that.
No.
Do not speak. Do not
To,
speak, sir.
of course, so I don't know, but it seems like he might be in violation of that cruelty to children bond condition. The state's recommendation is a $2,500 surety bond, no further contact with Brianna Kemp or that minor child, no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for Miss Brianna Kemp if she is on the Zoom.
Ms. Brianna Kemp? What are the initials for that child, do you know?
One moment, Your Honor. Let me get that for you.
RM.
RM?
Yes.
My initials, okay. How old is the child?
2.
2 years old?
I think that's correct. Is that correct?
He's holding up fingers. Is that correct? 2
Yeah,
years
he's
old?
holding up 2 fingers.
2 fingers. I can't see well. Oh my goodness. A 2-year-old been through all of this? Okay, go ahead, Mr. McClain.
Your Honor, on May the 13th, Judge Law ruled that a preponderance of the evidence upon her applying for a temporary protective order with regard to that incident in the vehicle, she dismissed that for lack of preponderance of the evidence. It wasn't dismissed for lack of attendance, so I'm assuming there was a hearing on the merits, but I don't know. I wasn't there. I haven't been able to confirm that with anybody. So they are both charged with, in the PI cases against them, they both have the PI cases, and they're both out on bond. But, Your Honor, this interference with custody case comes a few days before the August the 14th, I believe it is. Let me take a look. He has filed for legitimation. Their next meeting in court is supposed to be, I believe, in 6 days from now. And that's some kind of 60-day thing. I'm not familiar with the domestic side of things. Right. So, but it's a status hearing. So he has definitely filed for legitimation. I noticed a notation on the heading of that when I looked in Odyssey, paternity is admitted. I totally agree that it should go from no further violent contact to no contact. They need to do third-party transfer. I do not assume it was an unsupervised visit. I'm going to assume it was a supervised visit. But, Your Honor, I think a signature bond would be warranted, given that it is a delay in returning allegation. And I'm not gainsaying the fact that several days is a big deal.
And until the court enters an order legitimizing the child, It's my understanding of family law that he does not have any parental rights. So I think as far as custody goes, we should let the Superior Court handle that until an order is put in place. It should be no further contact. This appears to be the second time that he has taken this child and refused to return the child as agreed upon.
It doesn't appear that way to me, but I understand what the court's saying. I'm say the same.
Well, they're both. Is she out on bond now, or she hasn't come up yet?
I think
They're both
on bond.
right. Now he works. He is a CNA. He health worker, home care, works full time.
Is
And
that Miss Kemp who's come on?
And I'm looking at her bond order. I don't see.
she has 62 counts. He has 5,000 on one.
Yeah, I'm trying to see if there's any conditions on hers. Yeah, she doesn't have any conditions on her bond.
Does not. Okay. And where's the child now?
I would assume the child is with Miss Kemp.
No, that is an assumption I would agree with.
And Your Honor, it looks like in April of this year, just for clarification purposes, the defendant filed for legitimation and the victim filed for an ex parte TPO, which means she obtained a 30-day order. And then when it was time to have a hearing to determine whether or not that order was going to be entered in for 12 months, it was dismissed.
Okay. Okay.
Yeah, my only point on that was they had a line for if it was due to non-appearance, and that line was not checked.
And you all have spoken to her, but she couldn't be here today, or you haven't spoken to her?
We have spoken to her. She did state that she would try to be on the Zoom, but as I don't see her, something must have come up that prevented her from joining.
As a health worker, one of the two people, two or more people that he takes care of is his mother.
Well, I'm very concerned about this 2-year-old. I was hoping that y'all was a little older, but it's very concerning that a 2-year-old is going through all this. I guess the legitimation would be fine, but that will get him some type of parenting plan or visitation order if they can get along good enough to do it. And I'm not for sure that, and this has got to cool down somehow.
Your Honor, in addition, if I might, I do have a certificate of completion that I found in Odyssey that he, on June 27th, did the 4-hour baseline navigating family change seminar. So he's making some efforts there.
Well, he has to take that from the family division.
Yes.
So who is this person with the phone or the ID of Lobby, LOBBY? What case is that person here for? They're talking in the chat.
Is it me? Can you hear me?
I can. Who are you?
I'm D'Angelo's mother. I'm paraplegic. That's why I'm late. You see me in the bed.
Okay, but you weren't a witness to any of these incidents, nor were you there. Is that correct?
Well, the baby was with
No,
me.
No. Answer me yes or no. Were you a witness to any of these incidents or on the scene, or do you, specifically know from your knowledge about these incidents that we just spoke about?
Yes, I know about one.
And which one is that?
That is when the baby got hurt in the car.
And you were there?
Yes, they were at my house.
Oh, okay. Okay. Well, this is not the trial for those incidents.
I know.
And the state or someone else will be in touch with you. But I have a lot of concerns here. So I haven't sworn you in. If I need to, I will. And I have to see you to talk with you. I can't talk to you with your camera on. Okay.
Yeah, his lawyer told me to be here.
Okay.
Now, Your Honor, the final point I would make, and I'm sorry to keep adding to it, is just that in 6 days, there will be a hearing in a family court setting, and maybe that's the place to look at any modifications to visitation.
Mm-hmm.
I mean, we could maybe do it as a, no further contact with the minor child until a further order of the Superior Court, so that whatever, happens in that Superior Court case, that legitimation case, it will deal with
Right.
the
They
custody.
will.
And
Right.
ultimately, just for your understanding, you have a right to legitimate your child, and that doesn't get to be interrupted by us. But a judge has to determine whether or not you get visitation and custody, and they're going to take into consideration the fact that this defendant is withholding access to the child, and they should, and the fact that they both have criminal charges for acting in a negligent way that injured this child.
Mm-hmm. Yeah, that's very concerning and very disturbing. And it's not just one incident, so you all have got to get a hold of your emotions, whatever they are. And I'm sure everybody cares about this child, but they shouldn't wind up having the parents in jail, the child injured, and, grandma come in here. I mean, really, this has got to all stop. So, but I will say that Mr. McKeithen with seven prior arrests or 6 prior arrests, give or take, and the cruelties and all that, I don't know what it's going to take for you all to get along and co-parent in a safe and positive manner, but that's what you should be working toward. So I'm going to order a $2,000 I was going to do a surety bond. $2,000 surety bond. And no further contact with the victim and the child until further order of some court. I don't know if it'll be through another TPO or through the family division. And with those status hearings in the family court, they're by Zoom usually anyway, so he can get on from somewhere if he's still in jail or not. But I want no further contact with Miss Kemp or the child, both. I don't want him to have any contact until he has an order from the court that she can enforce and have in place for the protection of this child. No unprescribed drugs, alcohol, guns, or weapons while on bond. And I guess that'll be it for now. They probably need to go into some more parental counseling and anger management and a lot of things, but I'll let the case further down the road do that. All right, that's it.
All right, next we're gonna go position number 4 on the add-on calendar. Mr. Wilson.
All right.
Your
24
Honor,
C.
I apologize, but this is a conflict case, but we have not had a conflict attorney, Your Honor.
What does Mr. Wilson want to do?
Go say.
You want to represent yourself? You understand there are consequences to that. You're willing to take the risk in representing yourself and knowing the Georgia laws. Is that correct? I can't hear you.
Yes, ma'am.
Okay. All right. This is 24 CR 005553E. Monte Wilson, charged with 7 counts. 1 count possession of marijuana less than an ounce, possession and use of drug-related objects, willful obstruction of a law enforcement officer, giving false information to law enforcement, driving without a valid license, no insurance, and failure to obey a stop sign. Still want to represent yourself?
Yes, ma'am.
Okay.
Your Honor, actually, he does not go anywhere because he has other cases that he has to be incarcerated for. I would like to recommend to reset it till tomorrow so that he can have a proper representation. He is very young, 24 years old. He does need a lawyer.
All right.
Because he
We're gonna
says,
reset your case. Are you all gonna have a conflict defender tomorrow?
will we, Michael Jordan? I mean, I don't have a control over whether we are going to have a conflict attorney or not, but
We'll put in for one, Your Honor. I don't know whether or not one will be there, but I will put in for a request for one.
I would request that we go ahead and appraise him of the charges against him. He's in no bond status, as I understand it, in felony court.
Okay.
that's exactly why he needs to he can do it tomorrow, Your Honor, because I don't want him to incriminate himself.
Okay. So
Okay.
Riverside requires that we appraise him of his rights and he be heard in a hearing. It doesn't require that he get a bond or have a bond hearing. So as long as we're all clear about that, we would request that he be appraised of his rights so that there isn't an issue.
All right. Do you understand, Mr. Wilson? I've read the charges against you. Do you want me to tell you again what you're charged with, or you understand?
I understand.
Are you still willing to go forward today or wait till tomorrow?
You can go for it today.
Okay. All right, we'll go forward today. Pre-trial.
He got 8 cycles. He got an open capital case, 24 SC 002364. Open case in DeKalb County, battery DV 2 counts, 3 counts of simple battery, giving false name, disorderly conduct, cruelty in the third, 2 counts. 2021 reckless conduct, pointing pistol at another conviction.
Yes.
And check your chat, Judge.
Oh, okay. Thank you.
Your Honor, this is an incident that occurred on the 7th of August at 104 Fair Street Southwest. Police observed the defendant driving a Chevy sedan failed to stop at an intersection where there's a stop sign. They effected a traffic stop. He pulled into a driveway. He didn't have a license on his person. He smelled of marijuana and admitted he'd been smoking marijuana. Marijuana and a crack pipe were recovered from his pants pocket. When police went to detain him, he pulled away from the police using the full body of his weight. They had to call for backup. Eventually, he stopped resisting and sat down in the patrol vehicle. He gave the name Monte McCord, which is not his name. His name is Monte Wilson. Police located a 9mm Glock loaded in his vehicle under the driver's seat. He was confirmed to be unlicensed. He was also confirmed to have a grand jury bench warrant for homicide. Had not been arrested on that case until this traffic stop. And it was confirmed that the vehicle he was driving had no insurance. He does have 2 open felony cases for shoplifting and this recently indicted capital case. He also has a DeKalb family violence open case. We would ask for a $5,000 surety bond, Your Honor, no driving and no drugs, alcohol, or weapons.
How's your breakdown?
I would ask for $1,000 on each of the charges so the possession of marijuana and the possession of use or possession of a drug object, we would ask for $500 on each. And $1,000 on the remaining charges. As for a total of 6.
So there's more than 5, 6. Okay.
Thank you. I'm sorry. I'm bad at math.
All right. Mr. Wilson, you're 24 years old.
Yes, ma'am.
Do you work?
No, ma'am.
From Georgia?
Yes, ma'am.
Graduate from high school?
No, but I got my GED.
Okay, when did you get that?
When I was incarcerated, in 2021.
Okay. You have other family here?
Yes, ma'am.
All right. Are you living with any of them or you live by yourself?
I live with my grandma and my children.
How many children?
We got 6 kids.
How many?
6.
6 kids? Okay. When was the last time you worked?
A little minute ago, a little temp service job, like landscaping, cutting grass and stuff.
All right, I'm going to give you the $6,000 surety bond, 500 on the possession, the 2 possession charges, 1,000 on each. No unprescribed drugs, alcohol, or weapons while on bond. And I guess that's it. Because there's no stay away and no victims. It's traffic. Okay. All
What's
right,
that total?
that's it. 6,000, 500, 500, and 1,000 on the others. 600 surety.
You mean 6,000, Sheridan?
I mean 6,000. I'm sorry.
Okay.
6,000. Yeah.
Then you were homeboy.
All right, deputies, who we have next?
We can go back to position number 3, Mr. Gilmore.
Thank you, Your Honor.
Three on the regular or add-on? Let's see. What's the name?
Gilmore?
Oh, Gilmore. Okay. This is 24 CR 005547J, Philip Gilmore. Oh, okay, charged with that 1 count of sexual battery,